welcome to each one of you to the celebration of World Intellectual Property Day in this seminar hall. Hearty welcome to all of you. First and foremost, I express my heartfelt gratitude to our esteemed chief guest, Professor Mridula Gupta, Senior Professor, South Campus, Department of Electronics, Delhi University, Delhi, for gracing us with our valuable presence. Welcome, madam. She is not only academician but administrator and having a long senior professor, having a service of 40 years spent MSc in Electronics, first batch passed out of Delhi University MSc in Electronics. That time only three states where MSc Electronics is running, 1984. Madam is first batch pass out, then did MTech in Electronics from the same university and then appointed as a lecturer, and now she is senior professor. Professor से भी ऊपर का एक grade होता है. She is senior professor in the department. Welcome, madam. We are honored with your presence. Special welcome goes to our Honorable Vice Chancellor, Professor Sachidanand Shukla, in his absentia. He is the source of inspiration for such series of programs. I extend my sincere expression and sincere heartfelt gratitude to respected Swarnlata Saraf madam, Professor Swarnlata Saraf madam. She is coming first time in our department, so welcome madam. And आप यहाँ आ गए मतलब हमारा डिपार्टमेंट में बाकी बढ़ेगा, ये मैं मानती हूँ, क्योंकि यूनिवर्सिटी में फार्मेसी डिपार्टमेंट इज द टॉप मोस्ट डिपार्टमेंट. चाहे वो साइटेशन में देख लो, चाहे पब्लिकेशन में, चाहे डिसिप्लिन में, किसी में भी फार्मेसी डिपार्टमेंट टॉप मोस्ट डिपार्टमेंट रहा है और आज तक है. तो मैडम आ गई मतलब हम भी आगे बढ़ेंगे. Academician, but she is administrator and very good policy maker. She involved in so many government bodies for making policies. So welcome, madam. Today we gather here to celebrate World Intellectual Property Day, a day decided to recognizing the crucial role that intellectual property right play in fostering innovation and creativity across the globe. But before we delve into the significance of this day, let us take a moment to reflect on its history. World Intellectual Property Day was established by the World Intellectual Property Organization, WIPO, W-I-P-O, in the year 2000. To raise awareness about the importance to intellectual property rights and their contribution to innovation and cultural development. April 2026 was chosen as the date for this observance to coincide with the date on which the WIPO Convention came into force in 1970, aiming to promote and protect, not only promote and protect intellectual property worldwide. Now, why is this day is so important? Intellectual property refers to creation of the mind, such as invention, literary and artistic works, designs, symbols, names, and images used in commerce. These intangible aspects are protected by various legal mechanisms. What are those? Including patents, then copyrights, then trademarks, then trade secrets. Such protection incentivizes the individuals and organizations to invest time, resources, and efforts into creating new ideas, products, services, knowing that their intellectual property will be safeguarded from unauthorized एक्सप्लॉयटेशन. दिस इज वेरी इंपॉर्टेंट क्योंकि हर व्यक्ति को ऐसा लगता है कि हमारी चीज चुरा ली जाएगी, तो इसलिए ये IPR आया है जिससे वो प्रोटेक्टेड है. Intellectual property rights not only encourage innovation but also fuel economic growth. This is also very important. We are going towards the third largest economy in the world. So it protect the economy, not only protect the innovation, encourage the innovation, but economic growth, job creation, cultural enrichments. They provide creators and inventors also the recognition and rewards they deserve for their contribution to the society. Moreover, intellectual property rights facilitate the dissemination of knowledge and technology, fostering collaboration and progress across industries and borders. On this day, on this World Intellectual Property Day, let us reaffirm our commitment to promoting and protecting intellectual property rights as a cornerstone of innovation, creativity, and sustainable development. Let us celebrate the talent of creators and innovators around the world, and let us strive to build a future where intellectual property rights are respected, valued, and upheld for the benefit of all. Thank you.
Thank you very much, ma'am, for your address, sir. Now let us begin the lecture session with Dr. Mridula Gupta, ma'am, Professor and Head of the Department of Electronic Science of Delhi University, South Campus. Before we start, I would like to give a brief description about ma'am. She is also the Joint Dean, Student Welfare, University of Delhi. She is currently SRC Vice Chair of IEEE EBS Region 4, Region 10, and also Chairperson of IEEE EBS Delhi chapter from 2011 to 2016 and 2019 to 2021. Her name is listed in top 50 research guides across the India in 2019 by Wood's Wall of Fame. Her field of research is modeling and characterization of submicron and deep micron field effect devices. She has published more than 240 papers in various international journals, 370 plus papers in international and national conference proceedings, supervised 30 PhD students, and 6 more are working. So please welcome Dr. Mridula Gupta, ma'am. Please have a big round of applause for ma'am.
Good morning to you all, and first and foremost, I would like to thank the university and the respected Vice Chancellor of this university for putting me as a member in RDC, and then Professor Kavita Chandra invited me for an RDC tomorrow, and then she also wrote me for giving the talk on this intellectual property right. So it's my pleasure to be here amongst you and sharing things. She's already explained what is IPR and all. So I will go into a little bit more detail and we'll discuss about IPR. Though this is not my core research at all, but when Madam asked me that I have to speak on this IPR, so I thought, okay, let me just prepare some slides and let's see what do we have. So. Okay. So my outline of my presentation will discuss what is IPR. I hope I can reach you. IPR, what are different forms of IPR, patents. As Madam said, patents is very important into this. So my talk will be mainly focusing on the patents. What are patents? How do we file patents? What are the various kinds of patents? What is the procedure, timeline of the patent? Because people talk nowadays a lot about patent, that you should patent, but then it is not very easy to go for patenting. So we will be discussing some of these points. Then copyright, trademark, industrial design, graphical indications, semiconductor IC way of design, trade secrets, plant varieties and farmers right, they also come under IPR. Traditional knowledge, conclusion, and some references. So we start with what do we mean by IPR? So it basically says like if I'm involved into some kind of a research, or I'm involved into some kind of some guidance, or I'm developing a new design, then I want to protect my rights. Like I want to nobody should steal it from me. It should be my right. So that is why this IPR was created, and it says that how can I save myself from also like if I innovate some project and then I put it for a reference and then somebody says no, if I have not published and patent, or I have not published my work before, then somebody will say that no, it is my work. So that can cause litigation. So I can avoid myself from the litigations, and also how can I prevent exploitation of my own property, like whatever I have designed, whatever I am patenting, or whatever copyrights I want to take, how do I protect also myself? So all these comes under your IPR. So what is intellectual property rights? As Professor Gupta told you that it is a creation of property using human intellect. आप अपने जो रिसर्च करते हैं, आप कोई इनोवेशन करते हैं, कोई आइडियाज, आजकल स्टार्टअप्स बहुत आ रखे हैं. So all these they are all creation of property using a human intellect. And when you create something, then you want to protect your rights. Like you want to say this is my product. So this is what comes under your IPR, intellectual property rights, rights owned by the creator upon registering the property. So you will not get it anything automatically. You have to get it registered, and there are patent bodies available where you have to get it registered. It is very vital for economic development of organizations, as commercialization of IP create revenues. As Madam said that we are going to be the third largest economy in the world very soon. So nowadays, like we Indians never had gone into patenting anything on a very large scale. But if you patent your thing and then you sell it, you can generate revenue out of it. It provides ownership and exclusive rights over the created property, prevents duplication by others. So these are some of the advantages of, or this is what we call as IPA. These are the different forms, like they were in my first slide also, like what are the different forms of IPR: patent, copyright, trademark, industrial design, graphical indication, and so on. So we'll start one by one. We'll start with the patent first, because patent is the most important thing that I think all of you must know about patent. All of you have heard about patents, like what is a patent. So let us discuss what is patent, how do we get a patent, what are the advantages and disadvantages of getting a patent. Okay. Advantages of IPR I have already told you, so let's not repeat this. So patents. Patents is the word, it has originated from the Latin word petre, meaning to lay open. And to get a grant of the patent in the prescribed form, there is a fee, and there are patent specifications are required to be submitted to the respective patent office. Every country has a patent office. India has a patent office. You can apply for Indian patent. You can apply for Australian patent. You can apply for international patent. So there are different organizations available where you can apply for patent, and there is a form available. You fill up that form. You have to specify the specification, like what are you patenting. It is not like that I develop a model and I say I want to patent it. No. In that model, what is the patent I want, that I have to specify. I have to pay a fee for it. Nothing in this world comes free, so you have to pay for a fee for it. As I said, that the patent rights are territorial, and they can be extended to other countries by separately filling applications therein. So you can apply for a patent for the Indian patent, and then if you want to extend it to some other country, you can go for some other country also. Patent applies to invention of a new product of distinctive process, promoting its uses in industrial applications, and generally the patent has a life. It is not lifelong. It is they can grant it for 10 years, 20 years, and so on, and then you have to get it. Then it goes to the public domain. What are the stages? These are the different stages of patenting. As I said, you have to file an application. You have to specify what are you asking for a patent. Publication. publication of the patent, it comes to the public domain. Opposition to grant a patent. You apply for a patent, then it goes to the public domain, and then there can be challenges for that patent that this work has already been patented or has been done by somebody else. Next part is examination, and the last part is the grant of a patent. So it is not like you apply today and tomorrow you will get a patent. No, it takes minimum 6 months to 1 year to get a patent, or sometimes more also. So first is filing an application for a patent. So when you are filing for an application patent, you have to show a novelty of the work. It is not like any research work I am doing and I say, no, I want to patent it. I have to say what is the novelty. Like in my research work in electronics, we have worked extensively on the scaling of the MOSFET. I think if you are an electronics student, you know what you mean by scaling, but I have never patented my work because I don't know that I can apply it for patenting. We thought it is not good enough for patenting. But later on, we did on the miniaturization double gate MOSFET designing some 20 years back, and now we are seeing its product actually coming into picture. But we have not patented it. We didn't know at that time that we need to patent it. And that is why nowadays, whenever we are publishing a paper also, we always have to specify that what is the novelty in that work. So it is very important to discuss what is the novelty, obviousness or inventive setup, that what we have done, and then what is its industrial application. Like as I said for MOSFET, nowadays everybody knows what are the industrial applications of MOSFET. Miniaturization, because जो पहले इतने बड़े-बड़े आप कंप्यूटर्स देखते थे, आज छोटे से आपके एक स्मार्टफोन के अंदर सारी दुनिया समा जाती है, I should say. So that is the invention of the MOSFET. We have gone for miniaturization. We used to work in centimeters, then we came to millimeter, nanometer, and now we are going to sub-nanometer devices also. So novelty, as I said, how about you establish a novelty? You can establish a novelty by identifying the comparison with the existing work. It qualifies if any invention has not been reported in any publication or claimed previously in any document in any country. तो सबसे इम्पोर्टेंट पार्ट होता है कि आपने अगर मैंने अपना सपोज मॉस्फेट के ऊपर मैंने कोई सिमुलेशन किया है, फैब्रिकेशन नहीं किया है, सो आई शुड नॉट पब्लिश दैट वर्क. बट हमारे साथ क्या होता है कि एज अ टीचर जैसे ही हम स्टूडेंट्स देते हैं रिसर्च के लिए, तो हम स्टूडेंट्स को पुश करते हैं गो फॉर पब्लिकेशन. हमारे पीएचडी के अंदर सारी एक डिमांड आती है, आपकी 2 पब्लिकेशंस एसआई जर्नल में होनी चाहिए, 4 यहाँ होनी चाहिए. सो स्टूडेंट फोकस इज ऑन पब्लिकेशन. सो वी नेवर गो फॉर पेटेंटिंग बिकॉज पेटेंटिंग वुड रिक्वायर टाइम. सो इट इज फॉर द सुपरवाइजर एंड एज वेल एज फॉर द student who is working on to it to be patient if you want to file for a patenting. So examples of this just I am giving an example of disqualification for the patent grant due to non-filing of patent before publication. In femto we went mode. RPC 87, a patent was applied for inventing an improved nib for ballpoint pen. So this person has applied for a patent for this improvement in the nib. But the claim was disapproved because of the previous publication of the applicant about description of making ballpoint and making it public. So it is like a person himself has published some work. So that is why it got disqualified. So you have to be very careful while filing a patent application that this work has not been published anywhere, even by yourself also. I mean, you cannot say that it is my work only, but it has come to the public domain, then it cannot be patented. Second was obviousness or inventive steps. So invention should not be obvious to the person skilled in the related work. As per section 2(1)(j) of Indian Patent Act, inventive step is defined as a feature of invention that includes advancement in existing knowledge or having an economic significance or both, which makes the invention not obvious to the person skilled in that work. So if an invention is long awaited, has not been solved by another expert, then it may be applied for grant of a patent. So this also comes under patenting. Like obviously, you want to work on something and you are not getting the results, and then after long delay, you may not be skilled into that, you can apply for a patent. The third was industrial application. Lot of patents are filed for industrial applications because industries give you reward revenue. So the work which fulfills the criteria of being novel and non-obvious, then invention must be mandatory settlement and it should be the criteria of applicability in the industry. So these are the three criteria for which we file a patent. Then next comes the patent specification. It is very important to define a patent specification. What do you want to patent for? So patent specification in the document consists of a description about technical details of the invention for which legal protection is being sought. So basically you are looking for some statement or some work which you want to patent and you want to have a legal protection for that. It's a scientific and legal document. It's not a simple document. It's a scientific document because there's a technical information about the patent and there is a legal document that we want to save your legal rights onto this. And contents of the specifications are susceptible to interpretation by the court of law. The contents, also called as disclosure, are written description of the invention. So this is patent specification. Next comes Section 10 of Indian Patent Act 1970, which defines the content of the specification. Those who are more interested can look for these different sections. It provides the outline of the layout of the specification to express the technical output of the invention into written description. So there are specific words some 500 words or something for which you have to write down specifically what you are asking for. Like section 10 talks about contents of specification. So it has to describe very with clarity what is mentioned, what is the title you want to give to that. And it should be accompanied by drawings if required. Like if I am saying that for MOSFET we are going for scaling, then we should give a drawings or the description has to be given. And in some cases an application should be accompanied by model or sample to illustrate the invention clearly. But this is not considered as part of the specification. Again, further, every specification should describe the invention and its uses and method by which it is to be performed. Like if I am saying that I am designing a MOSFET with smaller dimension, then I should tell what are its advantages, what is its use going to be. Disclose the best method of performing the invention known to the inventor and for which he is entitled to claim protection. Ends with mentioning the claims defining the scope of the invention for which the protection is claimed on the new page. There is a company in its abstract to form a new page to provide technical information on the invention. Nowadays there are patent officers. अभी NTA में interviews conduct किए patent officer के लिए and it's a full-fledged you can apply for jobs in patenting. Like you can be a patent officer, you can go through these inventions. Again, we go for this contents of specification. If applicant mentions biological materials like bacteria or virus, then you have to deposit the samples. And there is an international repository authority at Budapest that you have to deposit your samples and everything that what you are claiming for. Because everything cannot be drawing. If you are going for biological sciences, there has to be some kind of the sampling has to be required. In India, such materials can be deposited at Institute of Microbiotechnology, Chandigarh. Declaration as to the invention shall be furnished in Form 5 with complete specification. There is a special form available for this, and it should be filled after a provisional specification which will include claims in respect of invention. So persons entitled to apply for patents to make a separate application for the patent. Then types of patent specifications. A patent application should be accompanied with provisional or the complete specification. Like you can apply for provisional. या पूरा आपने काम नहीं किया, but still you want to जैसे आपने कोई research करना शुरू करा और then you get some good results, so you can patent that, and you will say that you will go for the full specifications after certain time. So patent also give you that time period also. I'm going to that. In case of complete ready invention, an application with complete specifications can be filled directly without any need of provisional specifications. And this section outlines the statutory requirements for various parts of patent application and provides basic information used to prepare a patent application. What are the provisional specifications? Like, you don't want to disclose everything, you want to disclose a small part of it because there's going, you want some more time for completing the specifications. And again, provisional specification is scientific or legal and a document. You have to submit the complete specifications within 12 months to filing the provisional application. And there is a provision to post-date the priority date by maximum 6 months. तो आपको 1 साल का टाइम मिलता है बट 6 महीने के अंदर भी आप उसको करा सकते हैं. So a patentee can claim the earliest priority date based upon the provisional application. So if I go for this provisional specification, in nutshell, it is contains description of the inventions with drawings. Inclusions of claims is not necessary. Complete specification should be based on matter submitted in the provisional certification and should be filled within 12 months of priority. Failing which, your application will be abandoned. And complete specifications, they are filled after the provisional specification and they must be based on matter mentioned in the first case. ऐसा नहीं होना चाहिए कि आपने प्रोविजनल में कुछ डाला फाइनल में कुछ डाल दिया. No, they have to be contemporary. It must be even after the submission of provisional specification. And in case a claim as mentioned in complete specification is not based on the first disclosed, then the claim has priority date of filing complete specification within that claim. So you can file it separately. So what are the sequence required for complete specification? This slide has no video. So basically, this slide was there, which was showing that how much is the time required for filing the application. Patent of addition, like you can file for a patent of addition for second invention instead of filing a separate application. You want to add something to that, that provision can also be given. That is called as patent of addition. It does not require separate renewal fee to be paid, and when the main patent gets expired, the patent of addition automatically gets expired and has no separate or independent existence. Different types of patent applications. You can have a divisional application. When one patent applications consist of more than one invention, then the applicant must apply for patent for all individual inventions separately by filing a divisional application. एक रिसर्च लोग तो अकेले करता नहीं है, 4-5 लोग मिलकर कर रहे हैं. So everybody has to apply. You have to apply the names like who are the inventors in this. So this will help you in option of filing one patent application for several inventions while paying only one set of fee. And claims of both applications must not overlap at the time of drafting the divisional application and the main application. And reference to the main application must be appended in the divisional application. Ordinary application, so the first application for the patent filed at the patent office without any priority from any application or without any reference or any other application under process is called as ordinary application. They can be filled by the inventors or by the person to whom the invention is assigned. Conventional application is when applicant files patent applications claiming a priority date based upon the same or the similar application filed in one or more convention countries. So application is sent to the conventional application. तो आप एक साथ कई countries में application कर सकते हैं, इंडिया में, US में, ऑस्ट्रेलिया में, जहाँ पे भी आप लिख सकते हैं. And to get the conventional application status, an applicant must file application before any patent of it gets published. Before it gets published. Claim construction, like you can claims are the statements of the technical text which are expressed in your legal document. They are placed at the end of the specification also and must start from the new sheet. They should be worded very clearly and there should not be any repetitions. So you have to very specifically design your claim statement. It is very important. So claim constructions and apparatus for cooking rice. ये पूरी आने रही है मुझे लग रहा है. इसकी बात चली यार, ये ना मुझे आने लगे इसकी वो दोबारा से चलाना इसका और दूसरा दोबारा then go to this and pen drive ये वाला चलाना वीडियो देखिए उससे लाइन आई थी ना, मैंने आपको बोला था समथिंग वाज मिसिंग। ओके, मैंने मीडियम खोला है इसको। तो दिस आई वाज टेलिंग यू दैट priority date, like if you want to fill the application in 23, then the deadline is 24th August. There is post dating to 4 months. So new priority date after post dating and then deadline to submit the specification. तो शायद PDF खोलिए तो शायद बेटर रहेगी। So we were here, like I was there in construction. So for an apparatus for cooking rice comprising at least one container for holding rice in water and a heat source configured to transfer heat into the container. So it is like you have to have a preamble, like introductory phase, transition term or linking, and then the body of the claim. So types of claim, you can have a based upon on the basis of drafting. You can have independent claim, dependent claims, omni claims on the basis of invention, product claim, processor, method claims, apparatus claim on the basis of field, Jepson claim, and push claim. So these are the different type of claims you can have. Based upon drafting, like independent claim, it is not dependent on any prerequisite, it is not required for this independent claim. Dependent claim is if this happens, then that has happened, is kind of a dependent claim. So where the phrase wherein or in which is used to make connection between the two claims. And omnibus claims, like these include a reference to the description of the drawings without stating explicitly any technical features of the product or process claim. And the word like substantially as described or substantially as described with reference to drawing, they are commonly used. And then we have product claims. This refers to the claim made for the actual product, process of the method claim. आप कुकिंग राइस का भी दे सकते हैं, जैसे लोगों ने किस टाइप में दिया है होगा, या आजकल नए नए इन्वेंशन आ रहे, माइक्रोवेव हीटिंग, all these are the different kinds of claims. They are made in reference to the new process of the method to achieve the desired like method of preparation or method of analysis. Apparatus claim, claim made for a device or a system being used. You can have a based upon the field, Jepson claim and Brutish claims. Jepson claims are used for the process of the product claim where the invention is a modification or improvement in the existing technology. And we'll have a phrase like the improvement comprising of this. And Brutish claims are mainly in chemistry or biomedical inventions. It's like a claim with multiple functional equivalent chemical and entities allowed. Then the second step in the patent is the publication of the patent. First is you have to file, and then there is a publication for the public domain. So publication goes once a patent application is filed, it is published after expiry of 18 months from the date of filing. The applicant need not file any further application. So why it requires this 18 months? Because to study the patent, the patenting office will study the patent, will publish it in public domain. And if an applicant wishes to have a publication prior to 18 months, then you have to make a request for that. Then the opposition to the grant of the patent. So first step is after filing, second is goes to the public domain, and then there can be people who can put opposition to your claim. Somebody can say like this work has already been done by me, or patent officers or those who work in the patent office, they have to Google, they have to find out इस तरीके का काम कहीं पहले पब्लिश तो नहीं हुआ होगा. So this is their work. So this is what is the opposition to the grant of the patent. So this facilitates the opportunity to challenge the validity before and after the grant of the patent. And pre-grant opposition, it may be filed within 3 months of patent application, and post-grant is it may be filed within 1 year of the grant. Patent grant होने के बाद भी you can go for this opposition. Like if you think that this work is not authentic. Then the examination of the application of the patent. So there is a particular office available. The examiner checks whether the application is as per provisions of the acts or the criteria or the patentability. Then discrepancies are found. Then from the there are different examiners available for this, and upon the receipt, they will evaluate, they will go through your application, they will read each and every line, and they can ask you for clarification. That is called as your first examination review. Then the grant of the publication of the patent, the last one. So grant of the patent, once the objections and clarifications are sought, the patent is granted by the applicant by the controller, and as per the Patent Amendment Act 2002, the applicant has to pay renewal fee time to time to keep the patent in force. And once the patent expires after 20 years, then the invention enters in public domain and anybody can use that knowledge without referring to that. Okay, so this is about patent. Then quickly we go to time will be there. So we can go through next is the copyright. Copyright is the set of the rights given to the author for their original work by law. Generally, these copyright comes in the for literature, for dramatic, artist, musical, and for your pictures and all those things. And after pictures, they can see the copyright. So it is based upon this. This also includes a variety of work based upon photographs and computer programs. आपने कोई कंप्यूटर प्रोग्राम डेवलप किया, that also comes under your copyright. So these are coverage of the copyright from Indian Copyright Act 1957. Literary work, dramatic work, musical work, artistic work, cinematographic work, or sound recording. They all comes under this copyright. Duration of the copyright is 60 years. In case of the original literacy, dramatic, musical, and artistic, the works, the 60 years period is counted from the year following the death of the author. And in case of the pictures, sound recordings, etc., it is the 60 years are counted from the date of publication. Punishment for copyright infringement, you can be if a person is using your copyrights, then they will be under law of force, and there is a punishment and there is a fine also. And the next one is a trademark. Trademark is very important. This is generally for the business people, they want to have a trademark. So this is the identification of some specific goods, services, and souls like Nike, Patanjali, Britannia. They all have their own trademarks. It consists of combination of word letters or their numerals. It may also include distinctive drawings, symbols, three-dimensional signs like shape and packaging of the goods or the colors, and it facilitates the customer to purchase the goods easily, and it marks the guarantee consistent with the quality, and trademark advertises and creates an image of the brand. So you all know, I will show you some pictures. First let's talk about the trademark duration. Trademark duration is as long as the trademark exists, and the validity of the trademark in India is for a period of 10 years, as per the section 25 Trademarks Act 1999. So trademark registration also exists as long as a required fees is paid to the registry and regular intervals. Types of the trademark based upon their appearance, you can have a combination. Example, word like Google, Microsoft. So these are all trademarks. इनका कोई डिक्शनरी में मीनिंग नहीं है. अगर आप गूगल का डिक्शनरी में मीनिंग देखें, there is no meaning. So it is a combination of the word. But nowadays, it has become part of our life. Google, Microsoft. So these are all trademarks. These are word trademarks. शब्दों के trademarks हैं ये. These are the distinctive text only and typographic treatment of the name, product, service, company, organization or institution which is used for the purpose of identification and branding. Then you can have device mark. I think all of you know about this Apple. Apple has this trademark, and you know why this it says byte. You know, byte is BYTE. See, BY, all of you know what is byte. It consists of the bits. So it is Apple byte. So this is their trademark. So this is a device trademark. Service trademark like Nike, McDonald's, these are the service trademarks, and they are so you like businesses use these kind of trademarks to protect their names, and there are people who forgery also. वो M में ही उसका थोड़ा सा change करके they will say this is McDonald, but you know you should be very careful like the shape and the color both are the trademark of your McDonald. Nike has this. Just do it. Collective trademarks, these are used by the group of companies and can be protected by group collectively. Like CA is for Institute of Chartered Accountants, and CPA is used to indicate the members of the Society of Certified Public Accountants. So community को address करने के लिए you can have CA Chartered Accountant. Certification of the marks, like you can have FPO food products order or you can have BIS standards. So these are also the certification marks. आपका BIS very actually know that there has certain standards to this. And if all the food products, if you see this FPO, then that means this under comes under this food products order. So like these are the certification marks for electrical goods, toys, food items, jewelry to ensure their quality and safety of the product. Some well-known marks like this is for Mercedes. Orders, so such marks are not easier to be misused. Unconventional trademarks like color. Cadbury had gone for this color, purple color. This is Cadbury trademark. And you can see the sound trademarks also. These are perceived by hearing and this epic music so they कभी trademark के लिए so that comes for your you know that you come to know this is a music for that trademark. Shape marks. अगर आप कोका कोला की बॉटल देखें तो दिस इज द कोका कोला की जो बॉटल है ये इनका ट्रेडमार्क है बॉटल की शेप तो ये किसी और की नहीं मिलेगी आप कोका कोला की बॉटल खरीदे उसकी एक अजीब अलग शेप होती है so that is the trademark you will not find that in Pepsi or in any other item so these are the marks which are three-dimensional signs then the types of the trademark based upon the acceptance this is like you have fanciful words, Kodak, Pepsi. So such marks are invented words with no dictionary or other known meaning. It could be combination of two words and does not result a word that already has been used by other businesses. Arbitrary trademarks like Apple used for computers, BlackBerry for cell phones. So these are arbitrary trademarks. Then we have suggestive trademarks. Microsoft for microcomputers, Citibank for financial services, Jaguar for cars, and descriptive marks that are considered as weaker marks and very difficult to protect. They may not be registered or protectable. Like a pine tree shape is descriptive, but when used on pine scented products, so they have less acceptability. Industrial design. This is for Vespa. That's for Lancome. And they are the registered design for 15 years and initially they are granted so this scooter design is I think the French this Vespa scooter was the French design so this is very popular similarly like you can have geographical indication saffron is basically it's linked with Kashmir so saffron trademark is this is the trademark for saffron and Kolhapur chappals these are for the geographic regions they can be given. Then nowadays semiconductor layout design is also very popular. So semiconductor layout designs because you are doing innovation into the semiconductor आप इसको जितना छोटे से छोटे के अंदर उसको पिच करने की कोशिश करते हैं. So you can go for this kind of the layout designs also. And this semiconductor integrated circuit layout design registry is the office where applications on layout designs and integrated circuits are built for registration of the created IPR. Trade secrets, again an IPR, like it refers to the data or information related to the business, not made public to make it confidential, and it must have a commercial value as a secret. In India, there is no legal framework to protect it, but it is protected under contract laws or the law of the courts. Like Coca-Cola is a Coca-Cola formula is Coca-Cola company's secret recipe for Coca-Cola, and company presents the formula as closely held trade secret, which is known only to this executive when they are making this Coca-Cola. Then plant variety in farmer's life. Nowadays, this has come in a new one. You can grow different varieties of the plant. आप पहले तो आम की दो चार वैरायटी आती थी, आजकल मैंगो की there are so many varieties of the mango has come, and if you want to protect, then you have to go for its under IPR Act you can protect it. So registration of a plant for a variety provides the exclusive right to its holder to sell, produce, distribute, import, or export. Traditional knowledge, like this refers to the knowledge, tradition, skills, and practices that are sustained and passed on from generation to generation. आप अपनी cooking book बना सकते हैं, you can pass it in your family, and anything can come into this. So there is a traditional knowledge. Digital library is a pioneer initiative in India to protect the traditional medicinal knowledge from the misappropriation. आयुर्वेदिक में आप केरला की साइड में जाएं तो बहुत सारे आपको आयुर्वेदिक सीक्रेट्स मिलते हैं जो जनरेशन से चले आ रहे हैं. So that is called as traditional knowledge. So in conclusion, we talked about IPR, that they are very important to protect the rights of the creator. It facilitates the creator to be commercial benefits for their efforts, and one creative product can be protected under numerous variety of intellectual property rights. There is a stringent punishment should be imposed on the frauders in an expedition manner, and awareness about IPR must be spread to avoid anybody using someone else's IP with or without the knowledge of the existence. So these are some of the references I have used for this, and thank you very much. Any questions?
Any queries for ma'am? Any queries?
Just I am asking, what should be the criteria for the access of any kind of process for the student, even for the faculty? What should be criteria to easily access patent process for the student?
There is no easy way out. As I said, you have to wait. There is no easy way out. Preparing a patent application takes 1 year.
Yeah.
So you have to be patient. You just cannot file a patent without specifically, as I said, novelty. पहला नहीं होना चाहिए. So all these things you have to be very careful. So students of their own nowadays, like students are very bright. They can go for any innovations or the startups and they can file those patents.
I am just asking for the university campus. We can access for any for the campus, how we can approach?
For the campus, every institute has nowadays I think every institute has IPR cells. So there you can approach those cells. They will help you in filing an application. And nowadays I think universities and especially all the universities are promoting these patents because they give you a good ranking बढ़ जाती है. So there is the university is putting on money. I think क्या होता है जब आप पेटेंट फाइल करना चाहते हैं तो you have to pay a fee of about 30,000 to 1 lakh rupees, which is not easy for you to pay. But nowadays universities are supporting with some funds. If you apply for a patent, and ऐसा नहीं है कि आपने apply करा और आपको मिलेगा. Failure is always there, and that fees goes waste. You won't get anything back. That is why universities won't put in too much of money into this. So normally जैसे हम लोग अपना मैंने तो आज तक पेटेंट नहीं डाला because इतना टाइम भी नहीं कभी होता कि रिसर्च निकल के पेटेंट की तरफ जाए. But now I want to do patenting, but people invest money in that.
But people are doing patent. I बट आई एम जस्ट आस्किंग एक अगर हम लोग फाइल करते हैं फिर उसको पब्लिश करना चाहते हैं तो वो कितना दिन लगेगा कि
एक
हमको
साल मिनिमम एक साल
नहीं हमको वेट करना पड़ेगा कि पेटेंट
नहीं वो पेटेंट ऑफिसर अपने आप आपको बताएंगे आपने भी पेटेंट मैंने उसका स्टेटस बताया ना यू फाइल एन एप्लीकेशन दे विल रिव्यू योर एप्लीकेशन then they will examine that application there are patent officers with the full fledged cells which is available they will examine each and every line that we have written and will examine it and once they found it okay they will give you provisional it will go to the public domain in public domain again somebody can challenge that your patent then again you have to or there may be some queries so it is initially they will say that it will be provided and patent after this much time but that does not mean that patent has been provided to you so once everything is clear then they will issue you a letter that the payment has been granted
पेटेंट फाइल करके वो उसी जो काम है उसको वो अगर पब्लिश करना
नहीं कर
चाहते
सकते
हैं
आप पब्लिश कर देंगे तो फिर पेटेंट नहीं होगा
फाइल करने के बाद
हाँ फाइल कर देंगे
फाइल करने के बाद पब्लिश कर सकते हैं
नहीं कर सकते आप भूल जाइए उसको आप नहीं कर सकते तो उसका रेफरेंस भी नहीं दे सकते
ठीक है थैंक यू
Any more questions?
जैसे इंडिया में पहले उबर आया फिर उसका कॉपीराइट ओला बन गया तो
यार ऊपर है और ओला अलग अलग कंपनी है दोनों
सेम ही वर्क है ना दोनों का
नहीं वो तो बहुत सारी कंपनी है उस तरीके की आजकल तो ब्लू करके की कंपनी आ गई है सो देयर आर मेनी पीपल हैव डन नाउ दे आर वर्किंग ऑन द सेम प्रिंसिपल्स
कॉपीराइट इशू क्या था
इसके लिए कॉपीराइट इशू भी आता क्योंकि वो अपनी डिफरेंट सर्विसेज डिफरेंट रीजन्स और डिफरेंट सर्विसेज उसको प्रोवाइड करते हैं और समटाइम्स दे आल्सो हैव अ पैट कि आप कई कंट्रीज में वो कहते हैं ऊबर चलेगी जैसे हमारे यहाँ तो ऊबर चलती है ओला ऊबर बट they must have patented their work and then there must be an agreement between the two companies also.
मिनिमम चेंज होगा तो चल सकता है
हाँ
थैंक यू
Anyone else?
thank you so much. Yeah.
How it is decided that patent will for 10 years, 15 years?
It is depending upon the fees that you are paying for. You can get your patent renewed. Initially it is for 10 years, then you can maximum you can go for 20 years. So you have to pay fees for that. Every year I think you have to pay some renewal fees.
ट्रेडमार्क और सर्विस फॉर्म में कितना
Trademark what?
सर्विस फॉर्म
Trademark का अपना trademark में mark हो गया तो logo हो गया और service आप service जो provide कर रहे हैं वो service तो trademark का अपना trademark का मतलब किसी business को किसी logo के साथ promote करते हैं वो that is the trademark और फिर दूसरा क्या service is a सब kind of services that we provide.
Thank you very much, ma'am, for the wonderful lecture. You cleared the concept of IPR and patents for all of us. It was really informative. Thank you very much, ma'am. Please have a big round of applause for ma'am. Now coming to the next, Professor Mridula Gupta ma'am, former Dean, Faculty of Technology, Pandit Ravi University. She is currently the professor in University Institute of Pharmacy, Pandit Ravi University. She is one of the scientists in 2% world ranking of Elsevier evaluation and Stanford University, USA survey reports since 2017 to till date. She has various national and international official assignments. She has expertise in pharmaceutics, drug delivery, formulations, and cosmetic technologies. She has citations over 10,000. She is the first woman vice president of APTI, IPF, AASP Asia, FIS, and ISP. Let us welcome Dr. Mridula Gupta.